I guess that would be part of the discovery. The investigative report is within those 413 pages.
Okay. Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No,
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No,
And you didn't review the,
Phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And
yes.
The objection is sustained in part and overruled in part.
You testified earlier, in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that. did not.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes,
It was a Sunday, correct?
yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
All right, I'm with you, around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5-liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipts show, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone. You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as intoxicated.
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you, in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time were those?
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No,
Well, she didn't indicate to you that she forgot any part of the night, right?
right, she just didn't say that, so.
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
Not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours of, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? It's just yes or no.
No,
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
yes.
Conflict-free?
To her, she said it was a good day, so
Okay.
that's what she told me.
She said it was a good day.
Yes,
And there comes a point in time where the activities turn toward hide and seek, correct?
yes,
And she goes up to the shower,
right,
and when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes,
And that, in turn, made her mad.
that's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important
Okay. Then explain. Why wouldn't you ask that question?
because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
be
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No,
She never described him doing anything to make her mad, but it was words, correct?
right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment of that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs,
Yes.
and she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable,
Yes.
correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so, do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Fine. Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
It didn't contrast to the autopsy photographs or report?
Judge, I object.
Roach. You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
Yes,
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
correct.
She indicated that she ended up flipping the suitcase over face down.
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No,
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
no,
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
of course not, no.
No other questions?
Any redirect examination?
Briefly, Judge.
Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes,
Threatening someone's dogs, is that an example of someone using control?
yes,
Taking car keys from the other party, is that an example of control?
if they're withholding, yes,
Taking a phone and withholding a phone,
yes,
a debit card,
yes,
destroying a home, TVs,
Putting holes in the wall,
Yes.
not helping pay the rent and other bills?
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
As far as the state is concerned, thank you.
Mr. Owens?
Yes.
Thank you, doctor.
Thank you. Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary. Yes. All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
All right.
Okay, while the court is in recess, I'm going to go ahead and play this clip here. This clip is video from Sarah Boone's phone. Shows violent George Torres.
Call Sarah Boone.
Raise your right hand, please. Sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, you could take a seat, and if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
First name is Janella, Junella. Last name Wadden, UA, D as in Delta, AN.
Counselor, you may inquire.
Ms. Wadden, again, your official title,
Digital Forensics Examiner.
and are you referred to as a detective, or what is your...
Just an examiner.
Ma'am, Judge, can I approach the witness?
Yes, of course.
Ma'am, I'm going to show you what has been marked as identification defense exhibit AA. And you recognize that video or that CD of the video?
Yes.
Well, I think we kind of prepped you on it ahead of time. That was extracted from the Sarah Boone phone that you were asked to extract?
Yes, one of the media files, yes.
Okay, and is that video a fair and accurate depiction of one of the videos that was extracted from Sarah Boone's phone?
Yes.
And then identification C, defense identification, same type question. You've had a chance to review that video, and is that one of the videos that was extracted from the Sarah Boone phone?
Yes.
Judge, this time I'd like to have these introduced in evidence.
Any objections?
No objection.
All right, what was pre-marked as AA will be received into evidence without objection as defendant 17. What was pre-marked as Z will be received into evidence without objection as defendants 18.
Judge, we're going to play exhibit 17 first.
You may proceed.
And is there a volume? Judge, do you have control of the volume?
Volume is on.
Boone.
You may proceed.
We spoke about it earlier.
Say again, sir.
We spoke about it earlier.
Yes, understood.
They're tendering, no problems.
All right, thank you very much. This witness can't be released, correct?
Yes.
State?
Yes, sir.
Thank you.
I'm Vinnie Politan. The subject of my investigation is the suitcase murder trial. Sarah Boone and George Torres, they had issues. Issues with substance abuse and issues with one another. And in the end, those issues resulted in a grown man dying locked inside of a suitcase. Here's the story. On February 24th, 2020, Sarah Boone and her boyfriend, George Torres, were spending an evening together at Sarah's home. The couple had a bit of a tumultuous past. Both had been arrested on domestic violence charges, but they always seemed to get back together. On this night, the two were drinking, but what happened next is almost inexplicable. George got inside of a suitcase that was then zipped shut. Why and exactly how he got into the suitcase is not 100% clear, but what is clear is at one point, he wanted to get out. He pleaded with Sarah to open the suitcase, but she refused. Instead, she turned on the video camera on her phone and started to record George as he begged for his life. The following morning, she eventually called 911. She said she and George were playing hide and seek and George ended up in the suitcase. When police responded, they found George dead in the suitcase. Sarah has been charged with second-degree murder, but now claims she was the victim and is claiming battered spouse syndrome. What is the truth? So in most cases, when you're talking about a murder trial and a suitcase, that's where the remains end up, right? Sometimes people are unfortunately dismembered, put into one or more suitcases and their bodies discarded. Someone finds them and then investigators try to put the case together. That's not the situation. Here, the suitcase itself is the alleged murder weapon that George Torres is inside there locked and can't get out and dies as a result. So I want you to take a listen. This is Melissa Roughgarden, who is one of the CSI people, describing that suitcase and its dimensions.
This one curl is the reason I started my wavy hair journey. When I found Prose, I was desperate for a solution for my frizzy waves. I just wanted to be like the natural hair girly that I saw in Hair Talk. I took their quiz, which identified.
Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
So there you see the suitcase inside the courtroom. And that was the first thing that struck me when I saw that. I was like, that looks like pretty much a normal suitcase, not an oversized suitcase, but a very normal sized suitcase. Again, the first time you hear the story, you're like, what? A man was inside of the suitcase? I want you to take a look because what I have here, right next to me, is a suitcase with the same exact size, 28 inches by 20 wide, about 8, just over 8, almost 9 inches deep when you open it up. So this is it. This is the dimensions, and you look at, you know, how tall I am next to this, right? Take a look at that. I mean, so this is where George died, a suitcase the exact size of this, which brings me to my first question, and it's an important question, I think, in all of this, and it's about the suitcase, it's about George. How did George fit inside the suitcase? How does he get in there? How did that happen? Let me bring in my guest, my expert, forensic death investigator, professor of forensics at Jacksonville State University, and the host of the very popular Body Bags podcast. Joseph Scott Morgan is with us. Thanks so much. Let me just ask you initially, were you surprised when it was revealed the dimensions of the suitcase? It's a normal suitcase. It's the size of my suitcase.
No. Am I surprised that he fit in there, Vin? Is that the question?
Are you surprised that it
asking?
wasn't? I thought it was a supersized suitcase. I thought it was a jumbo. I didn't know. I had no idea the size of it. Now I found out it's just a normal suitcase.
I'm not necessarily surprised. I've traveled with my wife. I know how much can fit inside of one of these suitcases. So that's the reality of it. And you'd be...
All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dave Ketchtar on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone.
Kevin Beck for Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir.
Mr. Henderson?
Yes, sir.
Yes. Judge, there's 2 orders that I'm going to be requesting the court to take judicial notice of under 90.202 sub 6. And they're orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my position.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Redirect of Dr. Harper, saying that an element of control is talked about greatly by the state by pointing out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this Boone. These show that they were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Boone that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It just that doesn't mean that the paperwork comes in as evidence. So that's our objection: is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay, it's an order of the court. We're in a case where we've gotten in evidence of past domestic abuse. There was evidence of it started with the state about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. Certainly being offered for the truth of the matter asserted, no contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court.
But the case law says you can't utilize judicial notice to get around hearsay. I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 7th 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
Judge?
Yes.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order, it's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, Your Honor.
Any other argument, State?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body-worn cameras, Mr. Torres is like, well, you know, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay, all right, thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235, at pinpoint 253, by the Florida Supreme Court in 2011, which states, well, for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Judge, we do have the clerk of court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they sent some message to us back before the hurricane about what date they were to come, and we said to be continued. So we haven't gotten back up with them yet. So it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay,
But we haven't followed back up with them. This came up
sure.
late.
I'll give you an opportunity to do that.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner. It's probably going to take me a little bit to
Yeah,
find.
I'll give you that opportunity, absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes? 3rd floor? Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take them to do that, but we could present that in the morning and then rest in the morning, and then they could.
All right, that works for me.
I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
I won't object to them coming in, but it's a slippery slope for other records. We'll see what we do with that.
Okay. All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
I don't want to make the clerk come in.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang-up for the court and the defendant is that they believe a clerk of the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay, all right, fine. Then, based on the court, on the concession by the defense, or I'm sorry, by the state, excuse me, do you have any other objections with regard to these two non-contact orders? Mr. J?
No more objections.
Okay, for the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them, and then we'll identify them, please? The no contact order in 2019 MM 5062, dated June 16, 2019, has been pre-marked as AB. And the no contact order in 19 MM 5114, dated June 19, 2019, is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her,
Why we think we should rest, not call any further witnesses, not introduce any other exhibits,
just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant, but we do need some time with her.
Okay. All right, so then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow, and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. State, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it'll take on their part. And then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
If his direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction. And then reading a good bit of phone text messages into the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on dire spouse that we're going to be requesting.
Okay.
There'll be some There's different courts, Judge, here in Florida that have used, especially different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, and whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Brennan. There was a special instruction in that case. And then we've got some from other states. I don't know what the state's position is going to be on that, so we may.
Has a draft of that been circulated yet?
Not to the court.
Okay, all right. All right, so here's what we're going to do. Okay, let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you till she just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing, the state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read their motion and their proposed instruction. I have no objection to it.
Okay, all right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements, filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows: law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state, state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection?
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it.
So I will add this to the red line to be set out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language
to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial, and that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction: law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
okay. They got the courtroom muted, so but they're pretty much done for the day. So let's go ahead and pick up where we had left off before the afternoon started.
To my first question, and it's an important question, I think, in all of this, and it's about the suitcase, it's about George. How did George fit inside the suitcase? How does he get in there? How did that happen? Let me bring in my guest, my expert, forensic death investigator, professor of forensics at Jacksonville State University, and the host of the very popular Body Bags podcast. Joseph Scott Morgan is with us. Thanks so much. Let me just ask you initially, were you surprised when it was revealed the dimensions of the suitcase? It's a normal suitcase. It's the size of my suitcase.
No. Am I surprised that he fit in there, Vin? Is that the question?
Are you surprised that it
asking?
wasn't? I thought it was a supersized suitcase. I thought it was a jumbo. I didn't know. I had no idea the size of it. Now I found out it's just a normal suitcase.
I'm not necessarily surprised. I've traveled with my wife. I know how much can fit inside of one of these suitcases. So that's the reality of it. And you'd be surprised. The thing about the suitcase that you're talking about, I'm so glad that you guys picked up at least a template of this thing. I think that's very important for everybody to understand. Understand, this is not a hard-sided suitcase, and this plays into another factor that we'll get into in just a minute. But this thing's rather malleable. You can bend to a certain degree, particularly when you close that lid and you zip the thing up. You'll see how it kind of, I don't want to use the term balloons out, but it kind of pokes out a bit. So you've got a little bit of room in there. And we have to keep in mind that this victim, Ben, he is a tiny guy. I mean, he's very, very tiny.
Well, let's do this.
Yeah.
The video of George begging for his life as Sarah records him. For some folks, it's tough to watch, but I'm going to play it right now.
It's tough for me to watch, Ben.
Yeah, but it's important. It's probably the most important piece of evidence in the entire case.
It is.
So let's take a look and a listen to it, just to have a better idea of what we can gather from the video, what we see, and what we hear.
This is the reason why I've canceled my doorbell camera subscription.
This brand new subscription-free mini Wi-Fi camera provides more security features.
Sarah. For everything you've done to me. Sarah. For everything you've done to me. Sarah. You. Sarah. You. Sarah. Stupid. Sarah. That's my name. Don't wear it up. Sarah, I can't breathe, babe. Seriously. Yeah, that's when you do when you choke me. Sarah. 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 Sarah, I can't breathe, babe. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real or ransom. I want to get video for it extra. Because I got this. Sarah. Real or ransom. Sarah. Sarah, I can't breathe, babe. Oh. That's what Sarah. I feel like when you chewing on me. Sarah. You. Breathe, Sarah. Yeah. You should probably shut the up. Sarah.
So another important part, and you mentioned this, Joseph, is George Torres's size, and we now know his height and his weight. Let's take a look. 5'2", which is 62 inches, right? So
Yeah.
it's 28 inches high, 20 inches wide. He's 62 inches tall, but very slender, 103 pounds. So he's a very thin man. As we opened this up in the newsroom, and we had some folks who work here who are a little bit smaller, it seemed like the way you would be able to get in there is some sort of a fetal type of position.
Yeah.
And I think the suitcase would have to be lying down. It'd have to be lying down, and then sort of get in it in a fetal position. So if that's the case, what happens to someone who is stuck in that position? You know, over minutes, over hours, perhaps overnight.
Yeah, it's what we would refer to as a contracted position. If we were working this case out on the scene, so you've got him, you know, kind of in this position, knees are thrust up toward the chest, the shoulders or elbows pressed in, hands down, and you said it. You know, it is truly, he has to be in a fetal position. It's the only way you can accomplish this. But let's keep in mind, and I don't want to bury the lead here, but we know what the medical examiner stated relative to the cause of death, Vin. And she talked about that this was a positional asphyxia. Now, we see positional asphyxias, and if you'll give me just a little latitude, over the course of my career, I worked several positional asphyxia cases where I would have people that were heroin addicts that had fixed, say, for instance, on a toilet. They shot up on a toilet and then fell between the toilet and the wall. And they're in this kind of hazy, drug-induced, dreamlike state, and they can't move. And because they're so contracted in that position, their chest can't rise and fall. So, you know, the key to us living and sustaining life is to be able to uptake oxygen. It oxygenates the blood oxygenates the brain. And so without this, you're going to have an oxygen deprivation event. And it's a slow, agonizing. You know what's really striking to me, and she says this on tape, Vin. She says, you better shut the F up. What did she mean by that? Because for me, as an investigator and knowing what I know about death investigation, the more you talk, the more oxygen you burn. Okay, it requires you to have free oxygen to flow and to be able to converse with somebody and just conduct, normal everyday activities. She's telling him, you better shut up. Did she know something more? Does she know the fact that this is a position to be in oxygen deprivant circumstances? I don't know, perhaps.
Yeah. Joseph Scott Morgan staying with us. Coming up next, could George have died any other way?
The cause of death, which I put on the death certificate, is positional asphyxia with environmental suffocation. And the manner of death I classified as homicide.
Why did dogs live longer in the 1970s?
Back in the 1970s, a golden retriever.
There you go. The Sarah Boone suitcase video is deeply disturbing. It highlights the tragic consequences of a situation that escalated beyond control. It serves as a stark reminder of the importance of communication and conflict resolution in relationships. Watching such a tragic event unfold is heartbreaking and leaves a lasting impact. It has left a lasting impact on many family members of George too.
After her boyfriend suffocated inside of a suitcase.
He's in the suitcase still.
There are multiple domestic violence incidents.
You two hitting each other. Sarah. That's my name. Don't wear it up.
He told you, sir, I can't breathe. George Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Trial. Live coverage weekday mornings, 8/7 Central on Court TV.
I tried giving you CPR. The problem is I fell asleep. I fell asleep. When did you do CPR? This morning, when I found it. Before you called? Yes! 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, oh, he's in the suitcase still.
That video of the morning when police first respond of Sarah Boone always struck me as something just wasn't sitting right with the way she was acting, the way she was speaking. There's something that was off about it. And now the more we've gotten to know Sarah Boone, we understand that there are a lot of things about her that are a little bit off. And that gets us back to this story. So she's doing CPR the next morning. Like, she slept all night. George Torres was in that suitcase all night long. I want you to take a listen to the medical examiner here talking about the cause and manner of death, which is significant. It's part of what you need to prove your case. Let's take a listen.
Did you perform the autopsy?
Yes.
And what were your findings as to cause and manner of death?
So the cause of death, which I put on the death certificate, is positional asphyxia with environmental suffocation. And the manner of death I classified as homicide.
You also mentioned environmental suffocation. Could you tell us a little bit more what that means in more layman's terms?
So that just means there's not enough oxygen in the environment that the person is in. You could think of somebody who's in an enclosed space where there's a fixed amount of oxygen. So as that oxygen is, as that person is breathing, they're using up all the oxygen. And once it's gone, there's no oxygen left. Or you could think of maybe people who are, climbing Mount Everest. There's not as much oxygen up there, and that's why they have oxygen tanks. So it just means that the amount of oxygen available in the air around that person is not enough to sustain them.
So this testimony is significant. Obviously, it's
Okay, so it's going to be it for today. I'll be back on tomorrow morning, 8:30, 9 o'clock, to start streaming some more. I will not be streaming on Friday. It'll probably be later in the evening because they are working on power lines here, and we're going to be having our power off for quite a while. So probably sometime in the early evening, I'll come on with our Friday's trial. Till then, take care. And don't forget to, if you like this video, don't forget to hit the like button. If you haven't subscribed yet, please subscribe and watch the videos because I do need some watch time, people. I really need to get up there. I really appreciate already so far within a month and a half, I've gotten over 13,000 views. But I still have to get, as you know, 4,000 views in order to become a YouTube partner. So I really would appreciate if you share these videos, watch them, and because some of them are pretty interesting, especially this one right here. So we'll catch you tomorrow, 8:30, 9 a.m. Oh, and also you can follow me over on Facebook at facebook.com/SYMradio, and also on Twitter at formerly Twitter, x.com/SYMradio. So have a good evening, and we'll catch you tomorrow morning.